Letting Agents Limited, the Luton Borough Council.
Manning.
Well, may it please you, I appear with my learned friend Miss Sedgley on behalf of the appellants. My learned friends Mr Gullett, Lucy, and Mr Canning's offer of the local authority respondents. My lord, before I start, could I just check some housekeeping issues with the court? Because there seems to be a huge proliferation of bundles, and I just wanted to make sure that everybody has the same document.
Mm-hmm.
There should be a core bundle,
Yes.
a supplementary bundle, and an authorities bundle.
In 2 volumes, yes.
There are then some various supplementary documents that.
Well, there's an unagreed bundle as well, which
Yes.
I gather was the application for security for costs material.
Yes, I'm hoping that I can leave that for now, at least, until until the end, because if the court takes the view at some stage during the course of these proceedings that security of costs is a live issue, there's no dispute that the appellant is willing to give.
Yeah, but there's material in there which contradicts the first witness statement, and it'd be interesting to reassure ourselves that we can have regard to the second, I think it is witness statement, or maybe the third, when Mr Bain says for the first time that the first company was dissolved and the second company was formed in December. So that's the only reason I mention it, because that's the first time I found his evidence on that issue.
Well, I'll address that as and when it.
And then we've got a lot of loose materials that came in yesterday and the day before.
So.
And an application which will explain why it was made so late for, I think, the fourth witness statement from Mr Baines.
My lord, what I propose to do, if it is convenient for the court, is to leave the application to reduce a fresh witness statement until after I've addressed the court on standing on the basis of the materials that are not in dispute.
Right, yeah.
Not least because it's my submission that applying Ladd and Marshall, the court would need to consider what the impact of the new material is, and without having heard the appellant's case on the old material, it's more difficult and probably more time consuming to go into that. And it may be unnecessary to do so if we can satisfy the court on the basis of the material that's in already, that standing ought to have been accepted or granted by the court. So what I propose to do is to address the court, first of all, on standing, on the basis of the materials that are in the bundles and are not disputed, and then see where that takes me. And my lord, in my submission, the starting point, in a way, is the decision of Mrs Justice Williams below, which is in the core bundle at tab 9, and her statement at page 97, paragraph 56, where she says, I of course accept that as a local landlord, Mr Baines would have had standing in his own right had he chosen to bring these proceedings as the claimant, but he did not do so. In my respectful submission, that's an important point, which I will come on to explain why I say that as I develop my submissions on standing. The learned judge took the view that because Mr Baines did not bring his claim in his own name, but chose to bring the claim in the name of the company.
Well, he hasn't brought the name in the name of the company. A company, which is a separate legal entity, has brought the claim, isn't it?
Yes, but it's the company which everyone agrees is the company of which Mr Baines is the sole director and the sole shareholder. So,
is this an alter ego argument or an association argument?
Well, the judge.
You can't have it both ways, can you?
The judge described the company as Mr Baines' alter ego.
In legal terms, you establish limited liability precisely so that the legal person that has the limited liability is separate from the directors or the shareholders and so on, and that has various consequences. So I don't yet understand how Mr Baines, as a human being, brought in the name of the company when Mr. Baines, as the director, presumably decided that the company would bring it.
Well, my lord, I apologise for the inexactitude of my statement that he brought it in the name of the company. I don't think there's any substantive dispute between my lord and myself as to the fact that the claim was brought by the company.
Yes, and the letter before action says that they were instructed by, I'll call them Lala for short, or Lula for short, which is rather than repeating the whole name.
Yes.
But
Yes,
who
and
brought
that's-
this claim, and the person who would pay the solicitors would be the company. The person who would be liable for any costs, if there was a cost order, would be the company. So that's the only point. It's not Mr. Baines.
No,
Doing it, yeah.
absolutely, absolutely, it is
So
not.
the first sentence is actually right there in paragraph 6.
Yes, I'm not disputing that statement. In fact, I'm relying on it as part of my argument in answer to my Lord Justice Holgate's question to me, whether this is an alter ego case or a associational standing case. My primary position is that this is an associational standing case. But if I'm wrong about that, and if the judge was right that the company was Mr. Baines' alter ego, that does not mean that he should not have been accorded standing, or that, sorry, fell into the same trap. That does not mean that the company should not be accorded standing.
But this, don't we need evidence? Don't we need to say, Mr. Baines needs to say, this was brought in the name of the company, but in fact it's me, and I'm going to be paying all the costs and so on. You can't just have an argument and say black is white. You need to have evidence. And there's no suggestion in the evidence that this was brought, that the company was set up in some way as a vehicle for it rather than Mr. Baines to bring it. And indeed, the natural response would be, well, there's a better claimant. The claimant should be the individual.
Well, the company wasn't on the evidence set up simply to bring this claim. The company was set up in 2021. The second company was set up in 2021. The company, in fact, brought a previous judicial review challenging a previous licensing scheme brought by the defendant without any question of its standing arising. And indeed, that scheme was withdrawn by the respondent prior to permission being considered by the court. When it came to this challenge being brought, no question of standing was raised in the response to the pre-action protocol letter. In fact, in that letter, the authority invited the claimant to undertake mediation and to engage in a process of mediation. So at that stage, it would not, in my respectful submission, have been clear to the company or Mr. Baines as its director that there was a challenge based on the company's standing to proceed, both because he had proceeded in that way in the previous challenge without that issue being raised, and because before the claim was issued, the approach of the respondent was to say, we agree that mediation is a good idea, and we invite you to agree to it. So at that stage, and I'm not saying that the respondent can't now raise standing, but in terms of the evidence, or at least the evidence as it was initially put forward by Mr. Baines, it would not have appeared, in my respectful opinion, it wouldn't have been fair to expect him to go into detail about why the company was bringing the claim instead of him in his personal capacity.
You need to deal with a different point at some stage. There's a duty of candour on a claimant, and that requires him to say what he knows, or what he would be expected to know. And as far as I can see, there are question marks as to the accuracy of some of the statements made. Maybe just mention other things. Reading the statement, it says that from 2020, this claimant was acting in a representational capacity for landlords in Luton, that it didn't even exist until the 3rd of December. So you'll want to come back to that.
Well, I'll certainly come back to that.
On your secondary position,
yes.
the alter ego position, wouldn't you also need evidence about the relationship between the alter ego and the 31 members?
Well, if the company is simply the alter ego of Mr. Baines, my lord, then in my submission, the other members
They're
don't.
neither here nor there.
Exactly.
Well, you might need some evidence on that, because your primary case is they were here and there.
Yes.
That's why I'm struggling at the moment to see how you can run both association and alter ego consistently.
Well, I'm not seeking to run them both at the same time. I'm
No,
seeking
you
to run
couldn't.
them in the alternative.
Mm.
On the basis that if the court is not satisfied that associational standing can be made out, it's at least open to Mr. Baines to argue that he and his company are alter egos of each other, and that he as an individual having standing, that is relevant to the question of what the court should do in relation to the company's standing.
You know, you're saying that there was no challenge at the pre-action protocol stage, they were looking for mediation, so they wouldn't have known, neither the company nor the director would have known that a challenge would be made, and therefore it's not surprising you said that there was no evidence dealing with that point in the claim, yeah.
My lord, in my submission, respectfully, the purpose of standing is not to introduce technical rules to act as a snare for an unwary claimant. The case law, and much of it is in the bundle that I fed for submission, it's tried, going back as far as the NFSSB case, that the purpose of standing is to separate out busybodies, meddlesome individuals, in that case described as cranks, from those who genuinely have an interest in the subject matter of the claim. And in the supplementary bundle, there is, in my respectful submission, a lot of material that demonstrates that Mr. Baines' activities supporting and representing local landlords were well known and well documented, both to the respondents and to others. My lord, I don't know if we can go to the supplementary bundle just for a moment. On tab 26 is the witness statement of the local authorities housing officer at page 193.
Yeah.
And she is the head of private sector housing, which is in the first paragraph. She sets out at paragraph 5, at the bottom of 193 and the top of 194, that she has had dealings with Mr. Baines in his capacity as a local landlord. I know that in the latest response of the local authority to the application application to produce a fresh witness statement. It's said that it's disputed that he is a local landlord, but this is the council's own witness statement in which that is accepted, or as a representative of Ultimate Connections Limited, which is another letting and agency that he runs. And she says that she can recall in paragraph 6 in one of the consultation periods for the licensing scheme, at a landlord forum, Mr. Baines brought up the possibility of setting up an accredited scheme, and the full details of what he was proposing was sought. There's a dispute that he ever sent in detailed proposals. She then says at paragraph 11 that mandatory licence applications were made by Mr. Singh, Baines and Ultimate Connections, and a licence was issued to Mr. and Mrs. Baines for a property. So while she says at paragraph 12 that Mr. Baines says we also deal with the council on behalf of members raising concerns and making representations. However, I was unable to locate any reference to LALA on the complaints and queries database or the licensing database. It's not disputed by the council that they know Mr. Baines. So that's...
But the point she's making is that she hasn't had any contact with Lala.
Yes.
Lala's the claimant.
Yes.
All right.
But this is not the only point I'm seeking to make. It's the foundation of my submission. So I may ask just...
Yeah, do carry on, yes.
At paragraph 80,
So did you say 880?
8118,
I'm sorry.
paragraph 18 on page 195.
Thank you.
She says that the company dates of incorporation appear to coincide with challenges brought against the selective and additional licensing scheme. For example, the first company referred to at paragraph 15 above, that's Luton Landlords and Letting Agents, the first company that was dissolved and then a new company of the same name reincorporated.
Not reincorporated.
Incorporated.
Incorporated,
Yeah.
yes, that's the whole point.
Yeah,
They are
no,
separate people. A child dies, sadly, and a new child is born. It doesn't replace the first child, it's
No.
a second child.
No, it is a second company incorporated
And we give them the same
equal
name.
to after the first company was dissolved with the same name and the same director. I entirely accept that according to Chow, it's a separate company. But the company dates of incorporation appear to coincide with the challenges. For example, the first company referred to at paragraph 15 above was incorporated on the 23rd of June 2020. On the 30th of July, the council received a letter entitled Notice of Proposed Judicial Review Proceeding and Injunction Application from G. Willis. That letter starts, "I've been instructed by our client Raj Baines on behalf of Luton Landlords and Letting Agents Limited, an organisation set up to assist local property owners, landlords and agents to express and respond to issues affecting the locality of Luton, and was a challenge to the designations due to come into force on the 1st of May 2020. That matter was resolved by August 2020 without proceedings being issued." So, again, I appreciate that this is a separate company from 2020 and not the same company as the claim. But in my submission, for the purposes of standing, particularly at the permission stage, it is relevant to take into account the fact that the local authority have had dealings with Mr. Baines and his solicitor on behalf of the first company in 2020, and were told what that first company did, and then those proceedings were resolved by agreement. In addition to having been challenged by the second company in 2022.
In the first proceeding, standing wasn't challenged.
No.
So none of this tells us anything about whether the company has standing now,
But what
where it is challenged.
What it tells us, my lord, respectfully, in my submission, is that the authority from 2020 knew about Mr. Baines.
Yes, I've grasped
We know
that
that.
point.
And they knew about the first company, and they knew that it had ceased to exist.
and they knew about the second company,
It had been created in December 2021.
and which had brought a challenge in 2022.
Yeah.
Which was also solved without the issue of standing
So the
being
question
raised.
of standing had never been cast.
No. So, what I'm submitting is not that the local authority is not entitled to bring a standing challenge today. I'm simply trying to go into the facts and set out what, in my submission, the council did know, and what, for the purposes of the standing challenge that we face, the court, in my submission, should take into account.
Dealing with the second company, though, what do we actually know? All we know is that it was created at the moment in December 2021, and we know that a challenge was brought. I don't know if I've seen the pre-action protocol or whether a claim form or anything. So all we know is that a second company brought a challenge, and they may have thought, oh gosh, we have made a mistake here and we've corrected. We just don't know anything about it, do we?
Well, we only know that, in terms of the evidence before the court, that the second challenge was brought and before permission actually was issued, and before permission was considered by the court, the parties reached an amicable.
So was a claim form issued?
Yes.
So the claim form was issued, but was the acknowledgement of service filed?
There was a stay after the issue of the claim form by consent for the parties to seek to reach an amicable.
And then the matter was resolved.
And the matter was resolved. There was an order from the court under which the applicant company was awarded a certain amount of cost.
We haven't got any of that in the bundle, so we haven't missed it.
No, and I accept that the question of standing was never tested in that proceeding. In the same way as prior to the acknowledgement of service in the present case, the pre-action correspondence didn't give rise to any indication of standing as being tested. As I say, I'm not seeking to trap the authority into an argument that we're not entitled to raise it, but I'm simply saying that in considering the material as to the company, as to Baines in the round, these are relevant matters. And paragraph 20. I think I've got the wrong paragraph number. I'll come back to that point. I've got a note of paragraph 22, but it doesn't say what I think was the point that I was seeking to. Nope. Paragraph 23 refers to a legal challenge having been brought. No, that's not the point either. If I can then go, please, to page 207, page 206. This is a witness statement of the company's solicitor. largely in response to the application for security for costs. But it says at paragraph 5, I confirm that I've been instructed by the claimant company in the current matter and in the prior judicial review claim brought in 2022 under CO 1154/22. A claim which
Well,
was
this is just making the same point again as you've just shown us, isn't it?
This is the evidence that there was a settlement, yes.
I thought you were going to take us to 6.
well, I was going to as well.
Well,
But 5 is the evidence for what you just said previously about the big things about having,
He says at 6, he is aware that the claimant has a membership and has met with the group. And I do make the point that the company did show accounts with a figures of funds in the bank.
Well, the problem is we've shown a number of figures, and we were shown one set of figures in the statement that you haven't taken us to, which is the statement of the director of the claimant, the first one, and that said a particular figure. Then Miss Nelson, I said, well, hold on a moment, there are creditors, and the creditors are the same or are more than the amount in the accounts. And then there's this reference to 95,000, and what it is a one-page screenshot from Tide, which is one of those banks you see advertised on the underground, at page 212, and that's it, isn't it?
Yeah, that's the bank statement for this bank account for November 2024.
Well, it's a statement for one day, 8th of November to the 8th of November, and it shows that on that date there was £98,000 there, and £250 was paid in on that date. It doesn't tell us anything more than that, does it?
It tells us that on that date the company had £90,000 in its bank account.
Yeah.
But that's relevant to the security for costs application, which is not what I'm dealing with now.
No.
And obviously I'll need to come back to the witness statements themselves, but what I'm trying to show at the moment is from the authority's evidence and Mr. Bain's solicitor's evidence.
Well, this paragraph 6 says 3 things. One, it says that he's aware that the claimant has a membership, full stop. Second, it refers to a witness statement of Mr. Baines giving certain details, and for that we need to go to the witness statement of Mr. Baines. And the third thing it says is that on a particular date there were £95,000 in the bank account. Those are the 3 things that paragraph says.
Yes, and it's really the first of those things that he says that I'm referring to here, that he's aware that the client has a membership and that he's met with the group.
Yeah.
The statement of, or the first statement of Mr. Baines is at tab 24. Page 154.
Yeah.
I'm a director of the company Luton Landlords and Letting Agents Limited. I'm a landlord managing agent and property consultant within the proposed selected licensing with 5 affected properties. I have a further 4 properties in Luton that are outside the current area. So paragraph 3 after the statement of truth as such. He says Lala is a membership organisation set up in 2020. Now, I accept that.
Not true.
Well, it is true, my lord, that the membership organisation was set up in 2020.
referring to the first company.
The company which is I assume the service company, has had first a company that was set up in 2020 and dissolved in 2021, and now the current company, which was set up in 2021.
Sorry, I'm sure I'm way behind here. Paragraph 3 starts off with Lala. Lala has been defined in line 2 of paragraph 1 as the company which is now incorporated. Hence my Lord's question.
It was set up in 2020.
Sorry, I'll try again. Paragraph 3 refers to Lala. Lala is defined in paragraph 1 by reference to the claimant.
Sorry, my lord, I apologise. I missed the specific.
Sorry, it's my fault.
No, it's my fault entirely.
If you read this, you would think that the claimant, Lala, was established in 2020. That's the first thing you would think.
Yes.
And that's not true. It was established on the 3rd of December 2021. The one thing you wouldn't know is that a company was set up in 2020 which had the same name and was dissolved. And a different company, albeit with the same name, was set up some months after.
It was a few weeks after.
A few weeks after. But you know nothing.
No, you wouldn't.
What you're told is not true, and what you're not told is the truth.
But respectfully, my lord, in relation to the duty of full and frank disclosure, the question always is what you're not told, or indeed what you are told, relevant to the question that's before the court, any question that's before the court. I appreciate that this is a mistake that was made. This company was set up in 2021, not in 2020, and Mr. Baines did not go into the history of the companies that have been set up with that name.
Well, I'm puzzled about this because he's a director.
Yes.
He knows all about companies, and he knows about directors' duties, and he knows about companies.
Yeah.
And it doesn't seem to be a mistake. It seems to be a statement of fact. It was set up in 2020.
I'm not saying he was mistaken about the date. I'm saying it was a mistake not to have told the court about the first company and the second company.
Because the impression you get is that for the last 4 years, this company, the claimant, has been operating as a membership organisation, and that probably isn't true.
No.
What he said was it was set up in 2020, and its membership is open to both landlords. But if he's talking about the first company, that's one thing. It's hard then to know whether he's talking about the actual company.
What is true, however, on his case, is that, and I suspect I'm straying into dangerous territory here, but I'm going to have a go. A company bearing the name Luton Landlords and Letting Agents Limited has existed since 2020. It has not been the same company throughout that period, but there has been a company which Mr. Baines says has performed these functions since 2020. That is true in my estimation.
Just to get the context, this is Mr. Baines' first witness statement, 1st of May. It follows the summary grounds of defence, where standing was raised as an issue, and it follows the order of Sir Peter Laing.
Yes.
Okay, so this is the company setting out its stall in response to standing being raised as what actually decided by the High Court as being not established.
I accept that, and I've
Okay, I
accepted
just want
as
to
well.
make sure I'm following.
My lord, I've also accepted that it was a mistake, it was an error, it was wrong, if I can put it that way, not to have included in the statement the history of the two companies. I'm not disputing that. What I am disputing, with great respect, is whether or not, as a failure of compliance with the duty of candour, if the court sees it in that way, it actually makes a difference, or should make a difference, or should disqualify the company from being accepted as having standing. And I'll come on to that in due course. But what I do say is that the substance of Mr. Baines' using a company with that name since 2020.
We've gone through that. Mr. Baines doesn't use a company in the way that you would use a toolbox. Mr. Baines is a director with duties for one company, and that is dissolved. He's also a director for a different company and has duties there.
Yes.
You're still in the rigmarole of saying this was Mr. Baines's company, and there are different companies, and he's expected to tell the
Yes.
court that in a witness statement, which he says he knows the facts.
Yes.
And clearly he does know the facts because he tells us the truth later on. Anyway, so paragraph 3 we've looked at, it was set up in 2020, and we know that's not the case.
What is the case is that a company bearing that name with Mr. Baines as its director has been in existence, first of all, between 2020 and 2021.
So, and forgive me, isn't what really is important for our purposes is what does the claimant do?
Yes.
And isn't that what, if we move on, isn't that what is being described on page 155?
Yes, well, that's what I was.
Yeah, rather than going back to trying to justify the beginning of paragraph 3.
Well, that's what I was hoping to get to,
Yeah.
my lord. And he said that we had a circular leaflet that went to all agents, distributed leaflets at the landlord meeting. He describes membership fees. He describes services being provided to landlords and agents in relation to the private rented sector. Licensing scheme compliance checks and advice, assistance with applications, surveying properties, consultancy, a tenant mediation service and rental management services. He also says he deals with the council. Sorry, he also says we deal with the council on behalf of members, raising concerns and making representation. And he says he attended meetings, and some examples of these types of communication are exhibited. And he says we assist members in relation to other disputes with the council, and he has 31 members, 18 of whom are landlords and 13 of whom are letting agents. We are a representative landlords and agents organisation whose members, including myself, are directly affected by the introduction of a licensing scheme and who have grouped together to form a local association, part of whose purpose is to challenge the scheme with its members regards unlawful, which they could have challenged individually had they been able to afford the cost of doing so. And he says that Lala had discussions towards the end of 2022 with the private sector housing department, Mr. Karafalides, Mr. Stevenson, who was discussed at the Luton Landlords Forum, etc., to provide a tenant dispute resolution service, would give us accreditation.
The point that I think is being taken on the other side is that this relies upon the exhibit RB1, which has been included in the bundle. And these communications, I think, are mainly, if not exclusively, with ultimate connections noted. And they seem to, with one, possibly two exceptions, run up to March 2022. The consultation on the schemes which led to the designations under challenge didn't start until December 2022. So what's being said by the other side is, why is this relevant to the standing of the claimant? And then there's one email, February 2024 at 169, which is about a financial penalty matrix. I think that's the point you're being asked to address.
Well, what Mr. Baines says in his statement is that the company provides services to local landlords, which he has set out in detail, and that they...
But forgive me, sorry, it's a short point. When he says we, at the beginning of paragraph 4, it begs the question, who is the we? Now, a reader might think it's describing the claimant, but by the time you get to the end, you look at the exhibit, the we doesn't appear to be the claimant, it appears to be Ultimate Connections.
Ultimate Connections is a company, as you know, that
Has the same registered address.
Mr. Baines operates with the same registered address. I can't dispute what is in the bundle in terms of the emails that have been disclosed, but that does not, in my respectful submission, have the effect that either what Mr. Baines says in his statement should be dismissed, or that he has not been representing local landlords for the period that he claims. Now, I understand what my Lord Lord Justice Lewis has been putting to me about the claimant being the company, not Mr. Baines. And it may be that if the judge below was right, and that the evidence establishes no more than that Lala is the alter ego of Mr. Baines, that the question is not one that relates to whether or not the emails and other documents that have been exhibited demonstrate associational standing, but whether we're entitled to rely on Mr. Baines's evidence in his witness statement that he is a representative of a group of other landlords, combined with the evidence of Mr. Hussain, the solicitor, who says he has personal knowledge of having addressed the group, combined with the other evidence that I took you to at the start of Mr. Baines' obvious involvement with the council as a person who has been representing other landlords in connection with issues arising with the council. The emails themselves are plainly from and to Mr. Baines. I appreciate that Ultimate Connections is a different company and it appears on a number of the emails that we have in the bundle that I appreciate Mr. Baines has exhibited those.
And that's what he says is the evidence of the discussions between the company and the council. And what the council says, no, the first time we even see a reference to the emails in a footer to the head to the emails was sometime late in 2024, I think. I forget precisely the date. But at the moment, all we've got is an incorrect statement saying they've been doing this since 2020, and they haven't. They didn't exist. We've got 2 emails, and we can decide whether the judge was wrong with her interpretation of emails. And 3, we have a statement that the association currently has 31 members. Although I don't see in this written statement, I've seen another membership list, a list of the members.
Yeah. So
all we've got at the moment is that one sentence, plus we have the statement of meeting saying that you addressed a group.
Yeah. But, my lord, the bottom line of the Appellant argument is, even if the company was set up purely as a vehicle for this challenge, because see, the dates would not support that, data incorporation would not support that. But even if the company was set up specifically for the purposes of the challenge, and even if it is simply Mr. Baines setting up that company by himself in order for that company to bring the challenge, the company should still be accorded standing.
You really would have to have evidence. It's not argument. Let's think of an argument and see if it works. This is a matter, firstly, of fact. what is the company doing? And I haven't seen any evidence at the moment that says, I set up this company so the claim could be brought in its name rather than my name. If that had been said in evidence, the next question would be, why have you done that? You are the person that's got the interest, and normally you refuse standing to people who've got a less appropriate interest. The third question you would ask immediately is there a problem here about costs? But I mean, you haven't actually got any evidence. I mean, until this appeal, I don't think you'd ever suggested, had you, that it was set up as a company intended simply to act as a vehicle on behalf of the sole director.
I'm not saying that it was. I'm simply saying that even if that is the factual conclusion that the court comes to, as the judge below came to that factual conclusion.
Where does she come to that conclusion in her judgment?
She says, paragraph 52 on page 96. Of the core bundle, sorry. As I've indicated, Mr. Baines is the only named individual.
Oh, I see, yeah, okay, got it.
Taking this together with the formal company documentation I've already described, it seems relatively clear that the claimant is in fact Mr. Baines' alter ego.
Yeah.
So if she's right that conclusion was the correct conclusion that the court concludes she was entitled to have reached, then even on that basis we say, as a matter of law, the company should have standing.
But the answer to that is, potentially, and you have to address this, that there is quite a lot of authority refusing some people standing when there are more appropriate people who have standing. And if the only reason that standing exists is that Mr. Baines has got properties in the affected area, then he should be litigating it, not some other company, and he should be liable in costs. Or at the very least, you've got to tell the court that.
Well, we submit respectfully that there is authority in the authorities bundle that the fact that a company is set up simply as an alter ego of other people.
Of one individual?
Well, what we say about that is there is authority for the proposition that an individual can be, as it were, the representative of a company.
Yeah.
There is authority for the proposition that a company can be a representative for individuals, not all of whom have themselves standing. We respectfully submit that there is no difference in principle for the purposes of standing at the permission stage of any event as to why an individual cannot be represented by a company. An individual who has standing. We have the Rose Theatre Good Law Project line of authorities which say you can't give yourself standing by forming a company if the individuals behind the company don't have standing. And I don't seek to dispute or disturb any of those authorities. We also have authorities for the proposition that the company can bring a claim for claimants who do have standing, or some of whom have standing. What I accept, there is no direct authority on whether a company can bring proceedings on behalf of a single individual who does have standing. But bearing in mind what we submit is the purpose of standing, there is, in my respectful submission, no proper basis on which to draw a distinction between a group of 5 people, 2 of whom have standing, or a group of 1 person who does have standing. Now, I understand questions arise as to the use of the company. My Lord may have seen, I don't know to what extent my Lord had the opportunity to look at the authorities bundle, but the Blackfordby and Boothorpe case is one in which I think it was Lord Justice Simon,
Stephen Richards.
Mr. Justice Richards, as he then was, makes the point that if a company is set up without the primary purpose of avoiding a cost order, then, or even, he says in parentheses in paragraph 37, or even if that was the sole reason, then so long as security of costs can make provision for the other side to be secured in the knowledge that their costs are not at risk, there's no reason to deprive the otherwise viable challenge of the right to go forward simply on the basis of the technical application standard.
I do think there would be a second question then, don't you at least have to tell the court what is going on and the party what is going on, because they might think, oh, company fine, and then it may turn out that the company has no assets, and say you lose the judicial review, the individual is resting with nothing to do with me, that's the company. So don't you have to, if you're doing that, have to tell the court and the parties what you're doing?
But the court below knew, both because of Mr. Bain's evidence and bank statement, albeit the limited bank statements that I will refer to, but also because there was an application for security of costs, which the claimant was prepared to accede to. And before the judge below, it was the claimant's position that it was prepared to offer security of costs. I think the application, which is in one of the unagreed bundles, was for security of £75,000.
You said you do 45, I
The
think.
claimant offered 50 on the basis that some of that 75,000 in the cost schedule was not appropriate to be ordered at this stage, because there were issues of detailed assessment and the like. But there was no dispute as to the availability of cost. And obviously, if the claimant had made that concession and had not come through, then a condition on which the claim would in that hypothetical situation have been allowed to proceed wouldn't have been satisfied, and the claim would have fallen at that point.
The other way to do it is to do what the judge considered doing, which was to substitute Mr. Bain for the company, because he is, on this analysis,
Yes.
the claimant. It is better that the claimant takes charge of the proceedings, not using a role as a director of a company, and he would be liable in cost personally.
Yes.
And the judge decided not to do that.
But Mr. Bain's offered to stand in as the claimant.
He doesn't offer to stand in, he has to apply to be substituted, I think, what John does.
He offered to make that application before the judge. She rejected that application.
Well, she strictly said it wasn't necessary to decide it, because she thought, because the grounds were inarguable, she didn't propose to accede
Yes.
to that suggestion. Yeah.
And that was dealt with by Lady Justice Andrews on commission, in Elisabeth's commission, on a slightly different basis.
Well, the problem is what ought to have happened, I think, is you ought to have applied for permission to appeal on the basis that if the judge was wrong, that it wasn't arguable, that she was right on standing, then it should follow that the application should have been granted. But what you did do was apply to the Court of Appeal, which isn't the appropriate place to do it, and Lady Justice Andrew rejected that. But if we find that your grounds are arguable, you will want to say to us that if it is arguable, somebody ought to be allowed to do this, either Mr. Bain or the company giving security for costs.
Yeah.
So, in a sense, the important thing, in part, is to look at the grounds. I think you probably got the impression that we would have liked the claimant company, through its officers, to have been clear about the position. And it is deeply unfortunate that we're spending so much time on this issue rather than the actual grounds issue. But is there anything else you want to say on standing before you turn to grounds?
Well, I obviously can and was proposing to take the court to the authorities, but I don't have to do that if it would be more convenient to look at the grounds at this stage.
It's entirely
Yeah,
up to
there's
you.
just one question, if I may, I'd like to ask. You've taken us to Mrs. Justice Heather Williams' judgment, where she raises the alter ego point and suggests your client had been less than frank. That prompted, as I understand, as my lord has just said, an application to join Mr. Baines as a claimant, supported by the third witness statement, Mr. Baines. Paragraph 4 of which says, I'm the sole director and secretary. That does not mean, however, that the company is simply my alter ego, as I shall explain. I then went to the grounds of appeal to see if you were running an alter ego argument. I may have missed something, but I haven't seen it. So I'm slightly confused. The impression I'm left by the third witness statement is that Mr. Baines was not saying that the company is his alter ego, and he talks about the members again. Have I misunderstood?
The appellant's position is that the company is not simply Mr. Baines' alter ego.
Well, the word simply is probably redundant. It either is or it isn't.
Yes.
So it's not.
It's not, but if...
And all that Mrs. Justice Heather Williams did in that paragraph you took us to, it was to reinforce, she was saying, well, if it's not an association, it could be an alter ego, but as my lord was just saying, the real person who ought to be applying to be a claimant is Mr. Baines. Anyway, I didn't want to take up any more time on that other than to draw attention to those matters.
What we said, just to conclude my answer to my lord's point, in the grounds of appeal at paragraph 5 on page 16 of the core bundle.
Thank you.
Was that at 5.1, even if the appellant were Mr. Baines' alter ego, that does not support the proposition that does not have standing. And then at 6, in the alternative, the judge was wrong not to consider the application by Mr. Baines to be joined either as an additional claimant or substituted as a claimant in place of the applicant. So,
Look at Roman 3, though, at the top of page 17. It's a shame we have to prolong this. The judge was wrong to reject the written evidence of Mr. Baines and the solicitor. The company was not Mr. Baines' alter ego.
my lord, I don't dispute it. But the question that my lord asked me, respectfully, was, or put to me, was that we hadn't sought to appeal the judge below's refusal.
No, I didn't ask that question, Tom. I'm not going to repeat myself.
I think I asked that question, and I was actually trying to be helpful and trying to find a way around it, because I think what happened here was that the judge did not accept that on the evidence that the company had produced, that the company had standing. There was a separate question. There hadn't been an application at the stage as to whether a different person, Mr. Baines, should be joined, and she decided not to invite an application, in effect, for that purpose, because she thought that the grounds were not arguable. You have shown us things where you are appealing that.
Yeah.
At the same time as appealing that, you've made an application, I find it a bit of an odd application to the Court of Appeal, that he be joined to the claim. I don't understand how that can be at this stage, because there are no proceedings, because permission was refused. And Lady Justice Andrews has refused that application, but it may be the way to cut through this is if there were grounds which were arguable, then your the paragraph you showed us that the judge was wrong to say lacked standing on the grounds of is the way forward. But to suggest that we can do it on a factually false basis, which we're not contending for, is I think the thing that troubles us. We of course the law to proceed on evidence. And when Mr. Baines has said in a witness statement in your grounds of appeal says it's not the alter ego, it's not enough for us to say even if you were the alter ego, because we're saying you're not, and we must proceed on evidence.
Well,
but you've got the way that I can possibly see a way forward.
Yes.
If you can demonstrate that the grounds are arguable, yeah. Now, if you want to go to the authorities on standing, that's absolutely fine. Do take us to those if you think that would be helpful. Or if you want to focus on the grounds, that's also fine, yeah.
What I would like to do, if I may,
Yeah.
is go. I'm not going to go to all the authorities on standing as I was going to go to, because I think realistically, I've sort of set out my stall, and I'm not sure that the general authorities on standing are going to be of any particular either tell the court anything it doesn't already know with respect, or indeed take matters a great deal further. What I would like to do, however, if I could go to the case at tab 10 of the Bible to start with, and maybe just go to a few short passages from a few of the authorities. At page 121.
Or can we just get the facts, because the facts are critical.
Oh, sorry.
So this is that an insurance company was a member of Luton.
Yes.
It appointed WPLC as its appointed representative within the means of which section, yeah.
And W is a company called Winchester, is that right?
Yeah.
Winchester Group.
Yes, okay. So what was the issue here?
The issue on standing is whether or not the individual director was the right person to have brought the claim. We see it, page 121 of the bundle, page 45 of the report, in the section entitled Conclusions on Issues 1 and 2. Lord Justice Glidewell says, at a hearing before Mr Justice Otten, when he gave leave to move, counsel for Loutro raised the question whether the applicant had a sufficient interest to entitle him to make the application. The matter was not further pursued and was not raised before us by Mr Belloff. My own view is that the proper applicant was probably Winchester rather than the applicant personally, but I regard this as a technicality. The parties quite rightly treated the applicant as Winchester's representative for this purpose. This point therefore disappears. Now I'm not saying that's on all fours with the present case, but it's just a building block.
That's the director acting on behalf of the company, and it's not the judgment of Mr. Lord Justice Glidewell, still less is it the judgment of the other two, is it?
It is a view expressed by Lord Justice Glidewell, which in my respect was sufficiently persuasive. But as I said, I'm not suggesting it is on all fours with the current situation. I'm simply relying on it as one of my building blocks, if I may.
Yeah.
There is also the tab 12. The Blacksby and Boothorpe Action Group case, which was a case concerning, at page 150, an application for planning permission to extract coal and clay and for the subsequent disposal of waste by way of a landfill at a site near the villages in question. Planning permission was granted. The applicant was a company formed by residents. The applicant sought to challenge the grant of planning permission, and in response, HO argued that the company created for the purposes of making the application in such a way so as to avoid liability if costs should not be granted standing. And there were various arguments that were raised by the applicant. The first head note, holding, of page 151, BBAG had standing as an incorporated local action group, although technically it could be said that the company had no relevant interest of its own in substance. It represented the interest of local residents, many of whom had. The possible avoidance of substantial personal liability did not preclude the use of a corporate vehicle for making applications in circumstances where incorporation was not the sole purpose of escaping the direct impact of an adverse costs order. And if I can then go to paragraph 37 and 38 on page 169. Justice Richards, as he then was, made the point that incorporation ought not to be a bar. Technically, it may be said the company doesn't have a relevant interest. And then he goes on. Incorporation has a number of advantages, some of which motivate incorporation of the action group in this case. It is true that another advantage is the avoidance of substantial personal liability of members and costs, but that should not preclude the use of corporate vehicle, at least where incorporation is not for the sole purpose of escaping the direct impact of an adverse cost order, and possibly even where it is for that purpose. The cost position can be dealt with adequately by requiring the provision of security in a realistically large sum. And he then refers in the next paragraph to the increasingly liberal approach of the court towards standing of interest groups as the gross theatre decision. I don't need to take the court to that case in particular. The only, this stage, the other case I would just draw attention to is the case at tab 24. The thing on the application of Highnot and Secretary. This is not a standing challenge, correctly so called, but just note that the facts of the case relate to a decision about carbon capture and storage under the RHC. Paragraph 1 on page 457. Paragraph 2. The claimant company and a group of individuals behind it don't like CCS in relation to power generation and the reason why. And over the page on 458, the claimant is a company limited by guarantee which was incorporated the day before this claim was filed. The name chosen by the incorporators, Highnot, reveals the nature of its opposition to what, as appears below, is loosely known as the High-Net cluster. And then it represents a campaign group, which is a loose group of campaigners from different environmental and climate action backgrounds. Again, not on all fours with the present case, but it does, in my respectful submission, at least make good an example of the proposition that simply incorporating a company for the purposes of bringing a specific claim doesn't automatically rule the claim out of standing. May I just turn my back for 1 moment?
I'm so sorry, was standing an issue in the case?
No, as I said, it was not a case in which standing was challenged. I just say
How does it help us then?
I just say it's an example. If it's not helpful, so be it. I would submit it's an example of a case in which a claimant incorporated the day before a challenge was brought for the specific purpose of that challenge is not automatically excluded from standing. Indeed, standing is something the court could raise even if it was not raised by the other side. May I just have 1 moment? My lord, I just wanted to raise those specific cases before moving on to the ground.
Yeah.
There are 3 grounds which are pursued from the original statement of facts and grounds, which are set out in the core bundle at tab 16. And those are grounds 3, 4 and 5. there were two designations made by the local authority. A designation for what was called additional licence, which relates to the requirement to licence houses in multiple occupation. In other words, where rooms are let in an individual building by two different households. And also selective licensing, which relates to licensing where properties are let as separate dwellings to individual households. Ground 3 appears on page 209. And it raises a number of relevant considerations that we say were simply not taken into account at all.
I thought it was the data that was the issue on this appeal, but is it
Well,
not on the data?
Can I start with the data? On page 210. The point we make is that the information that was relied on by the authority in order to decide whether conditions for licensing were met, and those conditions was a report from the Building Research Establishment, some of which data was almost 4 years old, and some of it was almost 7 years old, and which we say was therefore not current, it was stale data. The statutory scheme, which I should perhaps go to and which is set out in the supplementary bundle. Starting at page 235 behind tab 28. For this purpose, the
Sorry, are we in the authority's bundle for the statutory?
no, it's in the supplementary
Oh,
bundle.
supplementary bundle, okay.
I'm not
I've got it, yes.
entirely sure that's the best choice made by the applicant.
I've got it now, yeah.
Behind tab 28, the first part of which is part 2 of the 2004 Housing Act, and that relates to the licensing of houses in multiple occupation. This part provides for HMOs to be licensed by local housing authorities where they are HMOs for the purpose to which this part applies, and they are required to be licensed. This part applies to the following HMOs. In the case of each local housing authority: A, any HMO in the authority's district which falls within a prescribed description, and B, if an area is for the time being designated by the authority as subject to additional licensing. So that is where we get the term additional licensing, which relates to the licensing of houses in multiple occupation, in addition to the mandatory licensing, which is under a national scheme. I don't need to go into the details of what licensing entails, but it is material in my respectful submission that by section 60 on page 239, it's provided that unless previously revoked, the designation ceases to have effect at the time that is specified for this purpose in the designation. 2, that time must be no later than 5 years after the date on which the designation comes into force. And in relation to part 3, selective licensing, which starts at page 244, we see that in relation to this, section 79 creates a similar scheme to houses rather than HMOs, to which this part applies. And this part applies to a house if it's in an area that's for the time being designated under section 80 as subject to selective licensing. And at at page 249, we see at section 84 the same provision that the scheme comes to an end after 5 years, the designation comes to an end after 5 years. Now, so far as selective licensing is concerned, section 80 on page 245 that makes provision for designation in terms that the authority may designate either an area of their district, either the area of their district or an area in their district as subject to selective licensing if the requirements of subsection 2 and 9 are met. Subsection 2 is that the first or second set of general conditions mentioned in subsection 3 or 6, or any conditions specified in an order under subsection 7 as an additional set of conditions are satisfied in relation to the area. And you will see from subsection 3 that there are requirements that are substantive in nature, if I can put it that way. The area is or is likely to become an area of low housing demand, and making a designation will, with other measures taken in the area, contribute to the improvement. 4, in deciding whether an area is or is likely to become an area of low housing demand, there are various factors that must be taken into account, among other matters. And they are empirical matters: value of premises, turnover of occupiers, number of residential premises available to buy and rent. Subsection 6 is the second set of conditions that relates to antisocial behaviour, which is causing a significant and persistent problem. I don't need to go into that, but if I can take you to subsection 7, the appropriate national authority may by order provide for any condition specified in the order to apply as an additional set of conditions for the purposes of subsection 2. And we have that order at tab 29, the selective licensing of houses additional conditions England order. An important part of this is that Article 3 of that order, conditions specified for the purposes of Section 80, subsection 3b of the 2004 Act. The following conditions are specified, which a housing authority must consider are satisfied in relation to the area before making a selective licensing designation under this provision. A, that the area contains a high proportion of properties in the private rented sector in relation to the total number of properties in the area. B, that the properties referred to in subparagraph A are occupied under an assured tenancies or licenses to occupy. And C, that one or more of the sets of conditions in Articles 4 to 7 is satisfied. Now, subsection 4, not subsection 4, Article 4, the first set of conditions is that having carried out a review of housing conditions, the authority considers it would be appropriate for a significant number of the properties referred to in Article 3.1a, in other words, private rented sector properties, to be inspected with a view to determining whether any category 1 or category 2 hazards exist on the premises. B, that they intend to carry out such inspections with a view to carrying out enforcement action, and B, that it will, in conjunction with other measures, contribute to an improvement in the general health condition. 5 are conditions in relation to migration, Article 5.
Does that just mean anyone who moves in, or does it have connotations of people subject to immigration control?
I think it's just anyone who moves in.
Anyone who moves.
The area has recently experienced or is experiencing an influx of migration. A significant number of the properties are occupied by those migrants, and that the making...
By the way, I've just gone back to your grounds of appeal, your statement of facts and grounds. This order wasn't based on 5, it was based on 4 and 6, according to your statement of facts and grounds.
Yes, I'm simply trying to show the court
The scheme, okay.
quite shortly, I hope, what the scheme was and the sorts of matters that Parliament requires to be taken into account.
So 1 is inspection, 2 migration into the area, 3 deprivation within the area, and 4 is the antisocial behaviour.
So Article 6 is in relation to deprivation. High level of deprivation affecting a significant number of occupiers of the properties referred to in 3.1a.
Yeah.
And the designation will, when combined, make a difference. And in determining whether an area is suffering from a high level of deprivation, the authority may have regard to the following factors in relation to the area: employment status, average income, health, availability of access to education and training, housing conditions, physical environment, and levels of crime. Don't need to go to 7. So the point that we advance in relation to our ground is that it cannot be right that an authority, and I'm now at paragraph 33 of the skeleton argument, can simply rely on data in deciding whether or not those conditions are met, that is as the most recent of which is 4 years old and the least recent of which is 7 years old. Bearing in mind 2 things. 1, that a designation is only statutorily capable of lasting for 5 years. And the second is the type of considerations that the authority have to consider are satisfied in relation to the private sector as a whole, how many properties there are and how those people residing are affected. To use data that was at best almost so old that a designation made on the basis of it would be coming to an end. And for the 7-year-old information, data that would have been 2 years old at the start of a designation, simply in my respectful submission, is not capable of being a sufficient or lawful basis on which a local authority can decide that at the date of a decision, its conditions are met. The reason I referred to the migration or article, the migration condition, is because it shows that the recency of the information is something that matters, given that in relation to migration it specifically sets out the word recently. And in my respectful submission, that is not a factor that is simply limited to background. We are talking about whether, in some cases, for example, an area is an area of low housing demand. That must mean currently, not was it 7 years ago. And we all respectfully, I would submit, know that the conditions in relation to the property market, private rented properties, as much as anything else, can change significantly in a period of 4, 5, 6 or 7 years. this matter was raised before the executive at the time it made its decision. And one of the suggestions made was that the authority should wait for more up-to-date data, which the executive decided not to do.
What they actually were told is could instruct officers to refresh the data,
Yes.
not wait for. Yeah.
Well, But
yeah.
on the basis that if they did so, it would cause a delay while they obtained that data. Now, in my respectful submission, it must be at least argued that refusing to rely on current material, where the material that is relied on is so very old, was something that affected, or may have affected, the rationality or indeed the relevance of the considerations taken into account in relation to that decision. The second aspect of this argument, which relates.
Before we leave that, I'm just looking at page 5 in the supplementary bundle, so I'm just trying to look quickly at what information was available. And at paragraph 10 it starts dealing with that, and it deals at 11 with the private rented sector in England, and then it says private rented sector housing is a large and growing proportion. And then it says in 2019 there was a report, which is the VRE report, as required by section 3. Now what was that concerned with? I couldn't see section 3.
I'm sorry, my lord, I haven't found where.
Oh, page 5 of the supplement bundle, tab 1, page 5.
Sorry.
There's a heading before paragraph 10, the current position, and then it goes on to deal at 11 with the size of the private rented sector.
Yes.
And then at 12 and 13 it refers to the 2019 report commissioned from BRE, and it says relating to the condition of the private sector stock as required by section 3.
Ah, section 3. My lord, section 3 is the section that requires a local authority, a local housing authority, to keep under review the condition and inspect the properties in its area,
Right.
for the purposes of part 1 of the 2004 Act, which is a system known as the Housing Health and Safety Rating System, which is the means by which Parliament has given local authorities a separate power to enforce standards in private sector accommodation. My lord, under the, I don't want to go into the history of this, but under the 1985 Housing Act, section 604 prescribed levels of fitness for private sector accommodation, whether it was fit or unfit accommodation, and a list of factors like damp, cold, things like that, which an authority would need to consider and had powers to require standards to be improved. That was all repealed by the 2004 Act Part 1, which set up a new, somewhat complex system called HHSRS, under which the authority has regard to the seriousness of risks caused by a large number of different potential factors. And Section 3 requires the authority to, amongst other things, consider and inspect the housing conditions in its area. The point in the report, however, is one that I was going to make, because it refers specifically to the paragraphs 11 and 12 and 13, the position in the Borough in 2019. It refers also, at the end of paragraph 13, to other Department for Levelling Up statistics for England as a whole from March 2021, by which they compared the 2019 data for the borough from the BRE report.
So if I were trying to link the figures that are in the BRE report to the statutory provision, which bit are the data in the report connected to in the additional licensing section that you've shown us?
So what's being considered in paragraph 13 is the condition from Article 3 of the additional conditions order, which says that I can't remember the exact word, a high proportion of properties must, go back to it. The area contains a high proportion of properties in the private rented sector.
So that's what that is linked to then, is it?
That is what that is linked to.
There's also information, maybe you're going to take us to this, Mr. Mann, but there's information further down the report, in paragraph 19 onwards, about the complaints which the local housing authority has received about HMOs and the sorts of problems that are encountered. Is that relevant for the purposes of this exercise?
My lady, may I come on to that in just one moment?
Sure, I mean, I don't want to take it out of return.
No, no.
Can I just make sure I've understood? This is dealing with HMOs.
This particular paragraph is dealing
This
with...
report is dealing with HMOs.
This report, there are two reports.
I know.
Which are in the same
This
term.
one is dealing.
This one is dealing with HMO.
So it's dealing with part 2.
This,
The order you took us to, the 2015 order,
Yes.
is dealing with part 3.
yes,
Yes, so it's not relevant to this report.
but
Okay.
Hang on, then I'm lost. You've shown us data and you've made your submissions about why that data can't be relied upon. And what I'm trying to do is tie the extent to which that data links to the conditions. And I've written down now that paragraph 13 is linked to Article 3 of the order, the requirement that there be a high proportion. Is that right or wrong?
my lord, the mistake I made was I thought that the first report that was in the bundle was the selective licensing report. There is a report.
So it's irrelevant.
There is a, well, I'll come on to why it is relevant, but the point I made is relevant to the report at tab 7.
Right, let me just pause
Which
then.
is in the
I'm
same
still on the report in tab 1, which is the selective licensing. And I'm trying to understand the link between the selective licensing and the condition. And you've taken us to Article 3, the high proportion.
Yes.
Is that right or wrong?
The report at tab 1 is not relating to selective licensing, but the terms,
Hang on. It is.
the report at tab 1
Is additional
relates to
licensing?
additional licensing.
Yeah. And
which
is that
HMO.
related to Article 3 or not?
No, that is not specifically.
Right, so when I've written down paragraph 13 links to Article 3 high proportion, that's wrong.
Yes, if
So what does paragraph 13 relate to then? I'm so sorry.
can I before answering that question refer you to tab 7?
No, because I want to know what paragraph 13 of tab 1. Tab 7 is a separate report on separate provisions.
Yes.
It'll confuse me, not help me to understand. You're telling me that when I do additional licensing, there is data in the BRE report, which is 4 years, 2019, and that's out of date. And I'm trying to compare what you say the data was being used for under the additional licensing provision. So I think it's likely to confuse me, Mr. Manning.
I apologise.
Because there are 2 separate designations. You might have grounds on one, but not on the other. So it would be helpful, now that I put a line through the reference to Article 3, if you could tell me where paragraph 13 is relevant in the additional licensing provisions of
So-
part 2.
Paragraphs 10 to 13
Yeah.
in relation to houses of multiple occupation and additional licensing appear to be setting the scene. Paragraph 10 says a separate report is before the executive relating to selective licensing. Although the schemes have similarities, they are legislatively distinct and require separate consideration. So the material about the private rented sector as a whole appears to be material that includes but is not limited to housing and multiple occupation.
Right. I'm at a loss.
Where
Is this data relevant to that designation order which deals with additional licensing? And if so, which paragraph is it relevant to? You said it's setting the scene. You've taken us to a particular provision, and that's the wrong provision, we know now. So I'm trying to work out if what you're saying about the data is relevant to that designation dealing with additional licensing. Did you follow me?
I do.
Yeah.
The fact that there is a BRE report dated 2019 is relevant. The specific proportions that it gives as to the PRS as a whole is not specifically relevant to the question of housing and multiple occupation.
Right.
Because
So why is it then irrational for the additional licensing to have referred to that BRE report and not to say you want another report?
if, for example, we go to paragraph 14 of that report, the BRE report estimated that around 80% of HMOs in the borough fall outside the mandatory HMO licensing scheme. So that's the same 2019 report, which is giving similarly out of date figures.
So what section would it be relevant to? If it was 60%, not 80%, or 95%, 90%, which condition would that go to?
It goes to not a specific condition, it goes to the overall decision of whether it is, well, I suppose what it goes to is the requirement in relation to additional licensing.
Is it section 56, subsection 2, page 236 of the supplemental bundle?
That the it's partly that, my lord.
Just say it again, so I've got a 56.
Subsection 2.
Yeah. A significant proportion of the HMOs of that description area are being managed sufficiently and effectively. That's looking more at the proportion of the HMOs,
Yeah,
not what proportion
yes.
is HMO.
That's why I said it's partly
relevant, yeah.
but also section 57.
Yeah.
Subsection 4. The authority must not make a particular designation under section 56 unless they have considered whether there are other courses of action available to them of whatever nature that might provide an effective method of dealing with the problem or problems in question. And B, they consider making the designation will significantly assist them to deal with the problem or problem.
And how is the data relevant to that?
Before I come to that, can I just go to one other statutory provision? Which is at where am I? Section I think that's going to help.
Can I see if I've understood this? When we go to part 3, you took us to the 2015 orders, and there's a number of detailed alternatives under which a scheme can be, a designation can be justified. When we're in part 2, the criterion which has to be satisfied for designation is 56.2, but and that's the only one. But in addition, as you pointed out in 57.4, before you make the designation, you have to look at alternatives.
Yes.
Is that the point in a nutshell?
Yeah.
Thank you.
And how do the data affect the alternative? That's what the question was.
Because in my submission, unless the authority actually knows how many HMOs there are in a particular area, and what the issues with those HMOs are, it can't properly consider, in particular, whether any alternative to licensing would satisfactorily deal with whatever problems it considers to exist.
I mean, going back to the report, the authority does direct itself at paragraph 17, page 6 of the supplemental bundle, to the statutory question in section 56(2).
Yes, it does.
And then, as my lady pointed out, at paragraph 19, it looks at when we're talking about effective management or ineffective management, the council refers to the complaints that it's continuing to receive.
Yes, but if one goes to paragraph 21 of that report, for example, the authority is using the BRE report to assert that the number of HMOs has proliferated between 2006 and 2019. 3,871 of which fall outside of the mandatory licensing scheme. That at 22, that South Ward has the highest number, and Dallow Ward and High Town Ward follow. Although it would appear that the highest number but the lowest proportion. And they then go on to consider that 25, their housing strategy, their previous housing strategy, and then their current and other strategic documents. And then at paragraph 28, they're comparing that data with data from the English Housing Survey from just a few months previous, which presents a national picture. Now, that goes through to paragraph 29. And then at paragraph 30, they refer to census data for England and Wales. And in my respectful submission, they're entitled to compare their own borough with the national picture if they think that's helpful. I'm not disputing that. But to do so effectively and lawfully, we would say, they have to do so in relation to equivalent figures. When deciding how many...
Do you mean borough-wide figures?
Borough-wide, or within the wards, whatever they think is the most helpful. But if they're saying there are 847 HMOs in South Ward, based on figures that are potentially 7 years out of date, that doesn't allow them, in my respectful submission, to decide the statutory condition, either that there are no other courses of action that will assist them to provide an effective method of dealing with problems they've identified, or whether a significant proportion of those HMOs are being managed sufficiently and effectively to give rise to problems.
So the only way the local authority to comply with the statute would be always to have recent data.
Yeah, so one can argue about how recent and what
Well, that was going to be my next question. It's a matter of judgment, isn't it?
In my submission, there comes a time when the judgment of a local authority cannot be lawful.
That's because that can only be because it's irrational,
Well, we would say
beyond
because
the reasonable bounds of what a local authority could do.
yes, because it's irrational, or alternatively because it failed to take into account the relevant consideration of the current situation in its area.
Do we need to do the same exercise with tab 7, which is the selective licensing
Yes, we
report?
can take that.
Because your submission is that this date was overlooked, and when you out of date, you need it up to date. And my lord has just gone through with you what you'd need for additional housing. You'd have to have an up-to-date borough-wide survey, or a relatively recent up-to-date borough-wide survey, in order to know what the proportion of HMOs and the likely alternatives is your submission. So we need to do the same exercise, so one has understood it in relation to 7. Because don't forget there are 2 designation orders,
Yes,
and it may be that your arguments are weak on one and strong on the other, but we need to check what they are.
it wouldn't necessarily have to be borough-wide. It could relate to the areas within the borough that were under consideration.
Borough-wide or areas within the borough, yeah, but areas for which they're responsible.
My lord, yes, and my lord, in my respectful submission, the argument is more focused in relation to service.
Yeah, well, that's what I want to understand. Yeah.
Given the terms of the additional conditions order. And at page 47, we have a similar set of data that are produced from the BRE report. At paragraph 12, at paragraph 13.
Hang on, I thought paragraph 12 was the general data about households, not BRE.
So paragraph 13
Yeah, 13 is BRE, isn't it?
and 14.
Yeah.
And then,
And here the focus is not on HMOs, but on privately rented properties.
yes,
Hence 15.
15, and then at 16 they say that they've confirmed the office by the Office of National Statistics Bulletin for the national privately rented figures and regionally for the east of England, but those are not the relevant figures for the borough.
So the national figures in 2021 are 20 and 18, and in 2019, 2 years earlier, the borough ones were higher.
Well, according to paragraph 14, in 2019, the private rented sector was 29%, but we don't have any figures as to what the private rented sector was in 2023.
For
In
Luton
Luton.
alone, we have it for nationwide.
We have it
So
nationwide.
we can compare the position nationwide and borough-wide in 2019, but we only have the national figures for 2023. Yeah,
Don't think we have
2021.
anything.
I mean, we're dealing with a local authority which can be assumed to be fairly aware of its local conditions. And at paragraph 14, looking at the borough as a whole in 2019, PRS accounted for 29% of dwellings in Luton, but Southward accounts for 49%,
It did in 2019.
much higher than the borough average. It's the town centre, as I understand it.
It did in 2019, yeah.
Yeah, I think the local authority would probably have a pretty good idea as to whether it's still a high proportion. It's up to them to decide, isn't it, whether they need to do a fresh survey.
Well, say for the fact that the proportion is not the only issue that they need to consider under Articles 4 and 6. And even if that were the case, and I don't respectfully accept that they can simply say, well, we know because we're the local authority.
And the point I've just put to you is in 19 Roman 1. the focus in Roman 2 is that they think there's a need to inspect premises. And that going back to the category 1, category 2 hazards.
But this is also going back to the position. But they're not saying, respectfully, in paragraph 19(1), anything except using the BRE figures. They satisfy the high proportion, but the BRE figures are the very same figures that are out of date.
Well, they're 2019, yes, you submit they're out of date. That's the figures that they've used. They're showing nearly 49.1% in 2019, and we also have the national average. And then the test in Article 3 is a high proportion of properties.
One needs to be careful about the 2019 figure. That is the date of the report,
Yes.
not the date of the statistical data within the report.
No.
Some
The
of which
report was
goes
December, I
back to
think.
2015, 2016.
Was that the deprivation indices?
Yeah.
Yeah, that's a different point.
Well, but it's relevant to the overall conditions which they had to be satisfied.
If we look at it as
with.
high proportion, then deprivation isn't relevant. It's a high proportion of properties in the private rented sector. That's why I want to tie it to the Act. So if it's Article 4, your submission is that they can't be sure that there's a high proportion in 2019 but they, when they make the order, because they can't rely on out-of-date data from 2019 or the national data or their own understanding of the area. They can't rely on that to be satisfied. It's irrational. But it's irrational, as you say, to proceed on 2019 data.
Well, data contained in the 2019 report,
Yeah.
which is itself older.
We're not on proportions, is it? I thought we've just gone through that. Deprivation is the 7-year and proportion of private sector.
Well, we have no data on what the current proportion is.
No, we're going round in circles, and it's very important to be accurate, and that's why I keep taking you to the conditions. Article 3 is a high proportion of properties. I'd understood a minute ago that you accepted, in response to a question from Lord Justice Holgate, that it was deprivation of the 2000, it was the 7-year data, and proportions was the 29 data. I don't think it matters, but if that's the position, then you're saying you can't rely on 29 data, or national data, or own knowledge. It's irrational so to do, is your submission.
No, it's not quite my submission. I'm not saying that they can't rely on up-to-date national data to set what the national picture is in relation to the average of the average proportion of rented properties nationally. That's more recent data, which, so far as the national data is
It
relevant.
would be irrational to rely on that and assume it applies to South Ward.
It's irrational to apply that as data relating to the borough when it isn't. I mean, if one looks at the different regions of England, the different proportions that there must be of rented accommodation in different parts of the borough, a national average, in my respectful submission, cannot be sufficient to satisfy Article 3, not least because Article 3 requires the authority to be satisfied that there is a high proportion, and the guidance which the admittedly non-statutory guidance which the Secretary of State has issued has said it needs to be higher than the national average. So to use the national average to inform the question of whether the local proportion is high.
But did they do that in the report? If you look at, for example, at paragraph 25, that just seems to be a summary of the national picture, which, as you just said, is a benchmark they would need to have in mind.
Yes, I entirely accept.
It's not actually saying because that's a national figure, we can assume it's the same in...
No, they're not saying that. I thought that was the point that my Lord Justice Lewis was putting to me.
Well, I'm just trying to understand what you're saying, and as I understand it now, it's irrational to apply the national data to the borough. It wouldn't be irrational to treat it as a benchmark because you've got to be above that from the guidance. Your real point, I still think then, is that they can't rely on the 2019 data for, or any other word you want to describe the data contained within the 2019 report, even with their knowledge of the borough and likely things like the number of universities and the number of people likely resorting to live in Luton and so on, they can't rely on the 2019 report containing data. They've got to do it again.
They can't rely on that as the sole information that they have before them.
On social, sorry.
Sorry, can I just ask you a question?
Yes, go on.
I might have misunderstood this, but what seems to be the case is that the figures from the 2019 report showed a higher proportion, significantly higher proportion than the national average. Would you accept that in 2019?
The 2019 figures show a higher proportion than the 2021 national average.
Yes,
Yeah.
right. Is it remotely likely that in the intervening period, the proportions of privately rented accommodation in Luton or in particular wards would have declined to the national average?
I don't know. That's the point
I'm
of
just
the
asking,
petition.
I'm not asking you, do you know? I'm saying, is it remotely likely?
I don't know if it's remotely likely.
Is it irrational to infer that it's unlikely?
My lord, without any figures, yes.
Yeah, but forgive me, I can understand that you will not know the answer to that question. But the councillors and the officers of this borough will be familiar with their area.
But
Take,
no,
for example, 19.3 on page 48 of the supplemental bundle. Deprivation. Levels of deprivation in South Ward is described as high. 59% of privately rented dwellings and the 20% of the most deprived, I'm not sure what that term means, in England. It sounds pretty bad.
it's lower super output
Yeah,
areas.
thank you. It sounds as if it's a serious situation.
It does, but it also relates to the position in 2019.
Of course, but as a matter of common sense, one would assume that elected councillors and also members will know whether or not the position has changed materially so as to be able to decide whether to spend public money on a fresh BRE survey.
First of all, my lord, these are not decisions taken by the council as a whole.
With executive,
These are things taken by the executive.
who have specialist responsibility, for example, for housing, and are well briefed on these matters.
Well, we don't. I mean,
That's the way local government works.
I understand, my lord, the point that you're making, and I understand how local government works. But with great respect, the report does not rely on any of that. It simply relies on data that have been compiled from the BRE in 2019. This is not the sorry. I was just simply going to say this is not the report is not the decision.
No, you've got to go to 57 as well, I think, because they were asked if they wanted to instruct officers
Yes.
to update the report, and they thought, yes, that would provide up-to-date information relating to the private sector. It would lead to a delay, which is something we've got to take into account, and it may provide no additional information to assist the executive in reaching a decision.
The key word there in my respectful submission was may. They weren't saying that there was no point.
Before we get to that paragraph, though, there's the summary of the consultation exercise at paragraph 52. A lot of people were supporting the HMO exercise, and then it's rather different on part 3 of 52.1. But I don't see any suggestion that anyone was saying you can't do this without an up-to-date survey.
Well, these are.
I mean, for example, did the claimant put in a representation, or Mr. Baines, saying you need an up-to-date survey for this to be lawful?
I believe that he did, but I don't have evidence in the bundle.
No.
But certainly, the 2022 challenge related to a similar.
Well, we don't know anything about that, and we're not dealing with that. So we've got your submission that for the selective, and it's the selective one, it's only the South Ward, it's not been the selective one. That's the only ward that's been the subject of the designation order for the selective one, or?
Yes,
Right. Just so I've got the facts right.
Yes.
And your submission in relation to the South Ward then is they couldn't rely on the 2019 figures because they were out of date. It was irrational to rely on the 2019 data, and it was irrational to infer that it's irrational to reach a decision which would assume that it hadn't fallen below the national average in 2023 or thereabouts when they came to make it. That's your submission.
My submission is that it was irrational. Alternatively, there was a failure to take account of relevant,
What were the relevant considerations that
the
they had?
updated material that officers offered to the executive.
They didn't have that, so that's not a relevant consideration they failed to take into account because it didn't exist. The question surely is whether it is irrational not to bring it into existence.
Well,
It's a bit like Katoon and making further inquiries, obtaining further information, which takes us, as my lord is saying, takes us back into rationality.
I accept that.
Because it's different from when there's something that they just don't take into account from do we need to go further and get information. They are different states of affairs. So that's your submission is the 2019 data. It's irrational to rely on that of itself for the South Ward and was not rational to proceed without getting further data and to infer that it's not below the national average. Yeah. So that's your ground one submission then, is it? That is because it's only data, or it was ground three below. That's your submission on that issue.
My lord, may I just reply on one point that was raised by my lord? About the consultation of paragraph 52. It is important in my submission that before one comes to the subparagraphs, these are only key headlines from the consultation that are being referred to.
Right, so do you then need to go to, is it ground 4 is your next one down below?
Yes. Round 4 is that the executive were told that the schemes would be self-financing and not costing the authority, when that was not the case and was known by officers not to be the case.
Yeah. The short point put against you is you look at 35, 36 and 37 on page 9 for the first report. They were told that they can't make a profit and they are able to set them at a level that makes them self-funding. They told in 36 that the plan was for a full cost recovery basis for administration and processing and compliance and enforcement functions. But they go on to say that there's going to be an additional early bird scheme. So the money that's being charged when you do the calculations for that is not going to be the cost of enforcement in the other areas. And what the judge said was it's obvious that, well, it could be one of two things. What she said is obvious when you read it all together that if there is early bird take-up, it may not lead to the full cost of enforcement being complied with. Another way of putting it is maybe less problems with enforcement if people have signed up and don't have to be paid to sign up. But anyway, that's the point put against you.
Yes, also paragraph 39 repeats the point that the schemes are self-funding, but there would be a revenue cost before any income is realised. So to be fair to the authority, were there?
Yeah.
But what we should say is that the authority were clearly told that these schemes were self-financing. It's not simply a question of the early bird scheme, because in addition, paragraph 42 of our skeleton on page 34 and 35 of the bundle, the licensing team in question.
So where are you then?
I'm on page 35 of the core bundle.
Yeah. Yeah, got it.
Paragraph 42(2). The emails that have been disclosed by the local authority show that the authority's officers were aware that the scheme as proposed would not generate enough income for the staff needed to be employed, and that they'd been told to make budget savings of £37,000, which meant that the report had to be amended, and we see this quite clearly from the emails that are exhibited in the supplementary bundle. Tab 20.
21.
Tab 27.
So, yeah.
And it's pages, I'm afraid it's incredibly small, but it's starting at page 233. And these are emails from March 2023 when the report to the executive are being put together. And we see about halfway down the page.
Which one, sorry?
Page 233. On the 31st of March at 11:51, Atika Chowdhury wrote, "Hi, Colin Day." Atika Chowdhury was a finance officer and Colin Day was a housing officer. Please send me the finance data.
Sorry, whereabouts on the pages? It's
It's about
233.
halfway down the
Yeah,
page.
sorry.
The date is the 31st of March at 11:51. And she says, please send me the finance appendices, I can't access the above links. Both reports say there is a net nil impact. However, we have a target of £37,606 to achieve in selective licensing, which has not been achieved in the past due to delayed implementation. If we spend all the income we receive on staffing, how are we going to achieve the £37,000 target? And the reply from Colin Moon, immediately above that at 11:57, is Atika. We cannot be explicit in the report about savings targets. Money from licensing is ring-fenced to these activities. If we broadcast that there's a savings target, that will be a line of attack for the next judicial review.
I can't see that. I mean, it would have been helpful to have done this. We're pretty elderly and our eyesight is already going, so you're going to have to take it much more seriously. I understand we can't be explicit about any income generation, but as below the report,
That's the next one up.
that's not the one you're
That's
reading,
not the
is
one.
it?
The one I'm referring to is at
Oh, I see. The immediate.
11:57.
Okay, we cannot be explicit in the report about savings targets. Money from licensing is ring-fenced to these activities. Yes. If we broadcast that there is a savings target, that would be a line of attack for the next judicial review. Yes.
And then Atika Chowdhury replies at 12:04. I understand we can't be explicit about any income generation, but as below, the report is explicit about the staffing spend. I think we should remove actual numbers of staff. Otherwise, we're saying to the executive, we will spend all the income we generate.
Yeah. So what am I getting from that?
And I just finished the chain. Atika, Colin Moon replies.
Can we take it the next paragraph starting with 1, the BR is not relevant?
No,
Thank you.
not to this point.
Thank you.
At 12:08, Colin Moon replies, Atika, we will make the savings target, but we can't say in the report. And then at the top of that page, Atika Chowdhury replies, I can't advise Dev to sign off the report, knowing the budget is not in line with the report. Therefore, if you remove the actual number of staff to be recruited, and we agree that recruitment will be on the basis of the budget being met.
What does this all mean?
What it means is this. The authority's report to the executive initially contained staffing costs for a number of staff, the specified number of staff who would be reported, on the basis of which the income generated by the scheme would be adequate.
Right. So the original draft report had a number of staff who would do the applications and enforcement.
Yeah.
There's a staff prediction, if you like, yeah.
Finance department then contact the housing department and say, licensing has a savings target of £37,500.
But what does that mean?
Yeah.
Well, what we say it means is that finance was saying you can't spend all the money you generate through licensing on paying for the scheme. You have to save £37,500 of the money you generate, and that means you can't afford to employ all the staff you said in the report you were going to employ, and we can't sign off the report unless you take those numbers out of it.
Yes. They took it out of the report.
Yes, they did, but what we say is that they never said to the executive, these schemes are not going to generate enough income to enable us to engage the number of staff we need. And that therefore for the...
Hold on. Yeah.
And that therefore the
Is
potential...
that solely because they're not, the information is not consistent with savings of 37,000?
Yeah.
I don't understand that entirely. There must be more to it because they can't use money from licensing and enforcement for other purposes anyway.
No, they can't. They're not.
So they can't use the 37,500 from that.
No, that's one of the concerns that we have about these emails.
So the officers are wrong. So the money will be there.
Could it mean just this, that there is licensing going on anyway in the borough, and this decision was proposing more licensing? What had been decided was that the total cost of licensing, whether or not it included these designations, be reduced by 37,000.
That would make sense, my lord, if the authority was subsidising the cost of licensing. That these schemes...
Well, you can reduce the cost of a service without introducing a subsidy. You can just try and be more, for example, more efficient. You can try and run the requisite service at a cheaper cost.
You can.
Yeah.
But that's, in my respectful position, not what they're... If they can't make a profit and they can't cross-subsidise, then...
They can try and do it more cheaply.
They can try and do it more cheaply, but then they're not amending the fee rates that they are proposing to charge.
But forgive me, the 37,000, was that, is there any evidence to say that that was referable only to these two additional licensing schemes as opposed to referring to licensing more generally?
The term we are told is simply that
Well, it refers to
we have a
selective
target in
licensing.
selective licence.
So that doesn't apply to the additional one then on your submission. It's only the selective one, is it?
Well, it's not entirely clear what finance are meaning by the term selective licensing. I can't go beyond what the email says. It does refer to selective licensing. But the point that's being made appears to be, at least arguably would say, you can't spend all the money that you are proposing to raise on staff, because if you do, and this is actually said, how are we going to meet the savings?
Yeah. But I mean, I don't understand that because they can't use the money from the additional licensing and the selective licensing for purposes other than administration and enforcement. So they must be talking about something else, or if they're not, the officers are wrong, not the executive. That's my problem at the moment. That's the stumbling block that I've got.
If they are proposing to make savings and therefore not spend the total fee income that they are proposing to generate, and they refer to income generation, which is presumably the fee income from the scheme, then in my respectful submission, this should have been made clear to the executive.
We've got two things. It's what they were told, and we'll come back and look at that in a moment. But am I just misunderstanding something, Mr. Manning? Somebody you think is saying something that's wrong. And one of the things I'm pondering about, and it'd be helpful if you could help me on this, is that irrespective of what labels we attach to this, fees that are levied for the grant of an additional licence or the selective licensing in South Ward can be used only for processing and for enforcement provisions. So you can't charge 100,000, use only 63.5, and get 37,500 for something else.
No.
So if in their emails these staff officers thought that they were going to use money from taking money out of the licence fees for other purposes, they'd be wrong. So isn't it a good thing they didn't tell the council that?
It may be a good thing that they didn't tell the council that they were proposing to act unlawfully, if that is indeed what they were proposing to do. But the point we're seeking to make is that if it is proposed to make those savings on the basis of which it is proposed to be unclear about how many staff are going to be appointed and potentially to appoint insufficient staff to carry out the functions required by the licensing schemes that are being introduced, then that has the potential consequence that in order to carry out those schemes, more money would need to be provided.
Well, if you were going to employ more staff.
If you were going to run the
But if
scheme,
you employ fewer staff, it may be the service is just run more slowly.
the point is, in my respectful submission, that this is information that the executive.
But what information? It's not clear to me what information you say they should have been told. They were told they can't make a profit. They were told the scheme was going to be operated on a full cost recovery basis, which I understood to mean that broadly the fees are going to reflect the costs of enforcement.
Yes.
So it's not going to be run at too much of a loss leader, although it could be, but it can't be a profit. They want to try and get the money back, but they've got to bear in mind the early bird discount as well. That's what they're told. And to make a scheme on that basis, where's the illegality on the part of the executive?
The executive approved a scheme that was going to be self-financing with a nil net cost to the council. The report as drafted initially made correctly provision for that to be the case, because the money coming in reflected the costs of the scheme. So the fees presumably were set to reflect the costs of the scheme. But the time Finance had refused to approve that report because they weren't supposed to be spending that much money on the scheme due to the requirement to make savings.
The
The
council
scheme
has
that
now authorised the scheme, and they're going to have to spend it, or they're not going to recover the costs. What they can't do is use 37,500 from licensing to a non-licensing fund. This is the scheme the council has approved. They've decided to designate on that basis, and whatever the staff say, they've got to do what the council has said.
But
I just don't see the problem. They have to do it now.
what we know happened is that because the authority, this executive, were not given the full picture, they were given a report that simply took out of that simply omitted the staff costs, the staff numbers. That the authority approved the scheme on the basis that was self-financing, which resulted in the authority not having, by the time it was due to be introduced sufficient funds to run the scheme. We know that because in our skeleton argument we've included reference to paragraph 43 to the Director of Housing saying, with 3 weeks to go, we'll not be able to stand up what we've proposed, as not enough money has come in. So,
I was going to ask about this. I mean, when you, as an officer, advise the executive that the scheme would be self-financing, it's on the basis of income coming in from licence application fees.
Yeah.
Yeah. So that depends upon making assumptions, of, for example, about how many such applications there will be. And your projections may turn out to be correct or not, but they're projections, not their estimates, aren't they?
yes, but what?
So when you take us to paragraph 43, that's a comment at that point in time about how the matter then looked to officers.
My problem is just simple. They decided to do the scheme. They were told that they're going to try and operate it on a self-funding basis, subject to the early bird thing, and that's what they've decided to do. If the staff find they can't do it, then they're going to have to go back to the executive and say, this just doesn't work. We just can't get. Well, they can always get enough. They'll have to increase the licence fees if they need the staff to do the enforcement. The problem is that if those emails mean that the officers wanted to use the money from the licensing for something else, they can't. If it turns out that the fees fixed don't provide for full cost recovery, and that's a separate thing, and that's got to be dealt with, they'll have to come back and look at the fees. But at the moment, I don't quite understand why it's unlawful for the councillor to be told you can't make a profit, we're going to try and run it on a full fund basis, but we are giving an early bird discount. I can't at the moment see, and they decide to make the scheme on that basis, I can't at the moment understand the illegality in their thinking. They can only take a decision on the basis of what they're told, and that's what they've done. Go for it, and go for it on a full cost basis. If that fails, it fails.
In my submission, where it is known to officers that the combination of the early bird scheme and the cost savings that are being demanded means that the scheme cannot be operated on a full cost recovery basis, and that therefore the executive were approving a scheme which was not in fact the scheme that was being introduced, because the scheme that was being introduced would depend on additional funds. The scheme itself includes the fees that are being charged, so that those fees are part of the scheme that are being approved by the executive.
I thought the fees were being dealt with separately from the designation orders. But don't worry about that. Anyway, so that's your submission, is that they were approving a scheme which couldn't be operated.
Yeah.
Paragraph 39 of the report does make clear that although the scheme overall must be self-funding, when you're beginning any such scheme, it won't be self-funding because you've got to put people in post and you've got to assess applications and set fees and so on.
Yeah, that's one of the paragraphs.
Existing resources were stretched when fees began to be paid. That's what they knew from previous attempts.
I did take the court to that paragraph deliberately because, to be fair to the authority, that there's a difference in my submission between a need to pump prime until the money comes in, and a need to subsidise the operation of the scheme in circumstances where the money won't come.
But they've decided not to have a subsidised scheme. The council officers may have got themselves into a terrible knot, because if they haven't told them that they're behind the scenes working to get 37,500, and that's not going to work, they're left with a scheme which is a scheme that should be what it is, one where the funding, at most, will recover the cost. It seems to me it's the officers' emails you're concerned with. I've got the point, I think. I can't relate it to the report and the decision, but I do have the point. You say where it's known to officers that the early bird discount and the savings needed, whatever they are, meant they were approving a scheme which could not be operated. That's your submission.
Yes, they're approving a scheme on the basis of what they're told, but what they're told is known to be in error by the officers.
No, the officers doesn't think it's going to work, and the officers didn't tell them that. So the officers now will have to make the scheme work, or go back and tell them we haven't got enough from the licensing. But I mean, there will be enough from the licensing because they can fix the license fees to cover the costs, say for the early bird discount. We go round in circles, you see. Anyway, those are your submissions on that.
Yes.
Can I just ask? I mean, this argument, as I think you said earlier on, rests upon the need to make the saving of £37,000.
Well, it rests upon 2 points. One is the early bird scheme, which means that the
Okay.
calculations don't add up, and the other is the need
Well, they
to
may
make-
do if, as a result of the early bird scheme, you spend less on enforcement generally. You don't need 10 people to inspect properties to see if they get a license. You need 6 people because a lot of people have signed up. You just don't know. But it's obvious that the judge said it's obvious that there might be a possibility that because of the early bird discount and it's £28 for enforcement, not 336, whatever it was, there could be a loss depending how many people sign up for it.
The report doesn't, however, make the point.
No, it doesn't say it expressly.
I didn't ask my question very well.
I'm sorry, my lord.
The point you made based on the emails and the exclusion of staff
Yes.
information and so on, that was related to the
Yes.
37,000, the saving in the budget.
Yes, my lord.
Can we go back to the supplemental bundle, page 15? As you've accepted these, this is all in the context of estimates as to how much scheme will cost in the future, with the aim being that it should be self-financing. As my lord said, that depends on how you set the fees. But if you've got page 15,
Yes.
there's a table at the bottom, finance. The financial calculations are based on licensing at the discount rate.
Yes.
This conservative approach to income estimation is supported by resourcing that will be based on workloads. Take together the budgetary implications for a net nil position. So this again, it rather reinforces the point. This is all a process of estimation.
I accept it's a process of
And we're
estimation.
talking, so far as this particular argument is concerned, about the accuracy of the estimation being sensitive to the 37,000.
So far as that element of this ground is concerned, then it is the question of whether the 37,000 should have caused there to be an amendment to the report making
Because
that
otherwise,
clear.
I was going to ask you, the challenge you're running is from the planning world, we would call an Oxton challenge. Is the report to the executive of all the members significantly misleading? And your complaint earlier on was, well, they took out the information about staff. And I was just trying to find the bit in the report where the information would have been excised. And that's how I landed at page 15. Do we have any more detail on the financing?
No,
We have paragraphs, lost it, sorry.
39.
Exactly, thank you.
in paragraph 39.
You have 35 through to 40.
It appears from
And yes, so
Sorry.
that's the information we have.
yes, it appears from the
There's no
email.
more detailed appendix dealing with finance.
No, it appears from the emails that the finance appendix was taken out. Because they didn't want to give the detailed figures. I would simply say in relation to page 15 that the financial calculations included in the report based on licensing at the discount rate, which suggests that the early bird scheme would be sufficient to generate a net nil position, whereas it's been accepted that that wasn't the case.
Well, it depends how you read it. I read it as the financial calculations included in the report are based on licensing at the discount rate, i.e. bear in mind that because there'll be some discounting, subject to that, it'll be net nil. I don't read it as because of, even with the discount rate, it'll be net nil. The calculations have been done leaving out of account the discount rate, and then it'll be net nil.
My submission is that based on means assuming the use of the discount rate in the sense that this is a conservative approach to income estimation. In other words, you're assuming that people use the discount rate. And even on that basis, which is a conservative basis of income estimation, you'll still break even.
well, we'll have to decide what we think the report means. Yeah. Right, now I'm sorry this is about time. I mean, you've really got one round left though, actually. And we have asked you lots of questions, but we wanted to give you the opportunity to cover everything and follow it through. How long do you think it'll be after lunch? Have you really got round?
I would hope to be no longer than 15 minutes.
Right, okay, so we'll try and not ask you any more questions and I'll let you know what the question is that's in my mind. Gaskin stops you charging fees that are unlawful in advance. You can't refuse to process unless they pay the additional enforcement fee. Hemmings says it's unlawful to require it up front, and they've done that for some people, it seems. But does that make the designations unlawful, as opposed to they can't refuse to process and they must give back any money that they've done? That's the question for you to think about over lunch.
I'll address the court on that.
Yeah. And then how long do you think you're going to
Well,
be?
I hope not much more than an hour and a quarter, but I'm slightly in the court's hands, as I suspect the learned friend is, in terms of his application to adduce new evidence, which he said he was going to make at the conclusion of his submissions on standing. I don't criticise him for not making it immediately, but the point is, I don't know where we're going with that.
Application?
Can I take instructions?
Yes, and have a word with Mr. Gallick and tell him over lunch whether you are going to be making it, and if so, how long it's likely that one will take, actually. Okay, well, that's very, very helpful. Thank you both very, very much, and thank you everyone else, and we'll see you at 2 o'clock.
Court's right, table.